Let's talk about one of the most powerful, yet most misunderstood, tools in financial planning, the family trust. You've probably heard the term thrown around, often associated with immense wealth or complicated legal jargon. But here's the truth: a trust isn't just for the ultra-wealthy. It's a versatile, essential tool for anyone who owns a home, has savings, cares for a family, and wants to ensure their assets are protected and passed on smoothly, without hassle, conflict, or unnecessary cost. The alternative, relying solely on a will, often means your family will have to navigate the public, time-consuming, and frequently expensive process of probate court. A well-structured trust can bypass that entire ordeal, providing privacy, control, and peace of mind. But the process of setting one up can seem like a black box. What type do you need? Who do you put in charge? What assets go into it? And is this something you can do yourself? In this guide, we'll demystify the family trust completely. We'll walk through the entire process from concept to funding, explaining the key decisions you need to make, the common pitfalls that can render a trust useless, and the insider tips for ensuring your trust actually works the way you intend when your family needs it most. This isn't about complex tax evasion schemes. It's about practical, responsible stewardship of what you've built for the people you love. First, we need to understand what a trust actually is. In essence, it's a legal arrangement, a three-party relationship. You, the grantor or settlor, create the trust and transfer your assets into it. The trustee is the person or institution you appoint to manage those assets according to the rules you set out. The beneficiaries are the people or organizations who will ultimately benefit from the assets. Think of it as a specially designed box. You own the box and set the instructions for it. You put your assets, your house, investments, bank accounts into the box. A trusted manager, the trustee, holds the box and follows your instructions to care for the assets and eventually distribute them to your chosen beneficiaries. The magic, from a legal perspective, is that once assets are properly placed in the box, they are no longer owned by you personally, they are owned by the trust. This is the core mechanism that allows you to avoid probate, since you don't own them at death. They don't need to go through your will, and provides a framework for management if you become incapacitated. The single biggest misconception is that creating the trust document is the end of the process. It's only the beginning. The critical, and often missed, step is funding the trust, actually transferring the titles of your assets into the trust's name. An unfunded trust is like a beautiful, empty box. It serves no purpose. The most fundamental choice you'll make is between a revocable living trust and an irrevocable trust. For the vast majority of families seeking to avoid probate and plan for incapacity, the revocable living trust is the workhorse. As the name implies, it's revocable. You can change it, amend it, or dissolve it entirely at any time while you're alive and competent. You can be the grantor, the trustee, and the beneficiary during your lifetime, maintaining full control. It's a seamless extension of yourself. Its primary superpowers are avoiding probate, saving your family time, court fees, and public scrutiny, and providing for uninterrupted management if you become ill or incapacitated, as your successor trustee simply steps in. An irrevocable trust is a different beast. Once you create it and fund it, you generally give up the right to change it or take the assets back. This relinquishment of control is what creates its advanced benefits, robust protection from creditors, and, in some cases, reducing estate taxes for very large estates. Because you no longer own the assets, they are typically shielded from your personal lawsuits. Special types like domestic asset protection trusts, DAPTs, or irrevocable life insurance trusts, ILITs, fall into this category. For most people starting out, the revocable living trust is the perfect foundational tool. The pro tip is to view them as a sequence, not an either-or choice. Many people start with a revocable trust for core estate planning and later establish irrevocable trusts for specific goals like long-term care planning or significant charitable giving. Now, let's walk through the concrete steps of setting up a revocable living trust. Step 1. Define your goals and inventory your assets. Ask yourself, who are my beneficiaries? Do any have special needs? Who do I trust to be my trustee? Then, make a complete list of your assets. Real estate with deed details, bank and investment accounts with account numbers, life insurance policies, business interests, and even valuable personal property. This list is your funding roadmap. Step 2. Choose your fiduciaries. This is a decision of immense trust. Your successor trustee will manage the trust if you can't. Choose someone who is financially responsible, organized, and, ideally, geographically close. You can also name a professional trustee, like a trust company or bank, for a fee which removes family dynamics from the equation. You'll also name a guardian for minor children in your accompanying will, a pour-over will that catches any assets you forgot to fund into the trust. Step 3. Draft the trust document. This is where I must give the strongest possible advice. Hire an experienced estate planning attorney. While online forms exist, they are generic and dangerous. A trust is a powerful legal instrument, and a single poorly drafted clause can lead to family disputes, unintended tax consequences, or the trust failing altogether. A good attorney will ask questions you haven't considered. What happens if a beneficiary predeceases you? Should distributions to young adults be staggered at certain ages? How should digital assets be handled? They will ensure the document complies with your state's laws. This is not a place to cut corners. Step 4. Execute the document formally. This isn't just signing. You, as the grantor, must sign the trust document in the presence of a notary public. Depending on your state, witnesses may also be required. This formal execution makes the document legally valid. Step 5. The most critical step: funding the trust. This is the active process of changing titles and beneficiary designations. For real estate, you will prepare and record a new deed transferring the property from your name to your name as trustee of your family trust dated date. For bank and brokerage accounts, you contact the institution. Provide a copy of the trust's certification of trust, a short document summarizing key points without revealing private details, and they will change the registration. For vehicles, you may or may not retitle them, depending on state rules. You update the beneficiary designations on life insurance and retirement accounts like IRAs and 401ks to name individuals, not the trust, as improper trust ownership of retirement accounts can create massive tax problems. Another pro tip your attorney will emphasize. This funding process is administrative but vital. An unfunded trust is useless. Once the trust is established and funded, management is typically straightforward while you're alive. You file your personal tax returns as you always have. For a revocable trust, there is no separate tax return because the IRS considers it a disregarded entity. You control and use all the assets as before. The real work begins for your successor trustee upon your incapacity or death. They have a fiduciary duty, a legal obligation of the highest good faith to follow the trust's instructions. They will gather the trust assets, pay any valid debts or taxes, and then distribute them to the beneficiaries as you directed, whether in lump sums, staggered distributions, or ongoing payments from a trust share. This all happens privately, without court supervision, which is the ultimate goal. A common mistake after setting up a trust is forgetting to update it. Life changes, marriages, divorces, births, deaths, and significant changes in your asset mix. Your trust should be reviewed every 3 to 5 years or after any major life event to ensure it still reflects your wishes. You can amend it easily with your attorney. In conclusion, setting up a family trust is a profound act of care and responsibility. It is a process of thoughtful decision-making, precise legal documentation, and diligent administrative follow-through. The goal is to create a clear, efficient, and private roadmap for your assets that removes burden and uncertainty from your loved ones during a difficult time. By understanding the roles, choosing the right type of trust, working with a qualified professional to draft it, and most importantly, fully funding it, you transform a complex legal concept into a practical shield for your family's future. It moves your planning from a reactive public court process to a proactive, controlled, and private directive that you design. It is the cornerstone of a modern estate plan. Disclaimer: I am not an attorney, certified financial planner, or tax advisor. The information in this video is for educational and informational purposes only. It is not legal, tax, or financial advice. Trust and estate laws are complex and vary significantly by state. The creation and funding of a trust have serious legal and tax consequences. You must consult with a qualified estate planning attorney licensed in your state to discuss your specific situation and to draft any legal documents.